very interesting. And now we have Dr. Lucia Lotti, public prosecutor in Italy, in Rome. The first practices in the application of the regulation.
Thank you, Anna Maria. I am very happy to be here. Is a great occasion. I introduce briefly myself. I am Deputy Chief Prosecutor in the Public Prosecutor Office of Rome. Rome is not a central authority. The central authority in these matters is the Ministry of Justice. But for my office, I am responsible for international cooperation in criminal matters. And so I would like to give you real life. It's really important to be here to discuss together, because in this matter, we are working with our rules, national rules, but in criminal activities, we don't find borders. Organized crime and other transnational activities are always conducted without question issues of jurisdiction, of competence, and so on. And so it's important to share not only reflection regarding the rules. We don't have uniform rules, but we hope to have uniform rules. Is very important. But it's also important to share our experience, to identify the link between rules regarding our tools against illegal proceeds and criminal dynamics. Because I think it's important to share methods and strategies all around in our countries in Europe. And so I said something regarding my daily life in my office. And we see every day when I receive a lot of European investigation order every day from all countries and from abroad. And we see a lot of different international activities. And it's incredible, it's an incredible panorama. I think that we know very well what are the most dangerous activities at the moment. We can find a lot of drug trafficking. I think is a real parallel economy. I don't know exactly what is the situation in your country, in your cities, but I see what is happening in Rome. We have areas that are living with the proceeds, just with the proceeds of drugs trafficking. And so we have this kind of parallel economy, but the same we can say about cybercrime. Cybercrime is a big problem at the moment. We have a lot of different kind of cybercrime, and there is a reflection on this matter also, and migration and smuggling of goods and trafficking of vehicles and criminal association that are in movement. At the moment, for example, Sorry, but this is real life. At the moment, we have in Rome, but I think the same is in Paris, and in Madrid, in other cities all around in Europe. We are Albanian criminal organization and Nigerian criminal organization, and all kind of organizations that are coming from abroad, but then that are working in a very fast way, in a very interconnected way. They don't have any question of racism and so on. The most important thing is to be a good criminal, okay? And after that, we have a relation with a lot of countries, and so we have the problem. We have the problem because with this kind of parallel economy, and with a lot of proceeds, huge amount of money that is coming from a country to another country, we have a very, very important responsibility, all of us. And I noted that one of the questions is the level of guarantees and the level of standard of evidence. This is most important. Is the most important things, because we have in Italy a lot of experience, because we have different tools against illegal proceeds, but not from yesterday. We have a long story, and Anna Maria Mauseri, I think, is our best expert in this matter. And so it's very important for us to identify the level of evidence. It's not important is a direct proceed of crime, is a extended confiscation and of preventive measure is not important. It's important to have a strong, very strong link between the crime and the proceeds. Every day we have cases in front of the judge. At the end, we have this kind of problem because the measure has to be effective, complete, and stable. It's not possible to accept a seize and after that a conclusion not positive for the public prosecutor office. Is a disaster. Is a very dangerous result. And so the problem is to find the most useful and correct methods to conduct the investigation. In Italy, in Germany, in French, is always. It's very important. And it's very important to identify exactly not only who is the person involved in the crime, but what is the crime, what is the person, not only physical person, but all other possible figures that can arrive in this kind of situation, and what is the proceed. This is important, but it's important not after investigation, but from the beginning of investigation. For that reason, I say that the problem is the method that we have shared all around. I think it's important just to give an idea of our asset at the moment regarding international cooperation in criminal matters. In Italy, we have 26 public prosecutor office that can conduct investigation after request for judicial assistance becoming from other countries. Okay, we don't have central authority, but just to have an overview on this matter is the Ministry of Justice. In this case, I am speaking about European investigation order. Okay, this is important because it could be, we can find a difference between competence regarding European investigation order and the execution of the certificate, but we are waiting for a new. I don't know if Michele told about that. We are waiting for a new regulation on this matter because at the moment I cannot be more precise. Well, why I am talking about European investigation order? Because we need the results of European investigation order before to arrive to seize an asset, because we need information. Yeah, it's possible to send European investigation order and a certificate, but it could be a problem. The problem is to have the exact idea regarding what I can gather with European investigation order and what I need to arrive with a certificate. Well, allora, this is the results of a search. What you can see in these slides, the total request, the total of requests of European investigation order that in Rome arrived from other European countries in
Only in Rome.
Yeah, only in Rome.
Wow.
Okay.
For 5 years.
Yes.
Yes.
Only in Rome, but in Italy, for that reason, I told you, 26 public prosecutor office. The same level of numbers is in Milan, in Naples, and in other another district public prosecutor office was not the same level, and you can see that we have a lot of requests from Germany, from the most the cases of fraud, web fraud, okay, and so we can say that European investigation order is a good tool. Okay, I think we are used to use European investigation order as a normal way to conduct investigation when we have cross-border activities. Okay, and I can give you another data. This is the type, the figures of crimes that are on the ground of European investigation order that we are dealing with in my office. And so we can see that the problem is cybercrime. But we have a lot of cases of drug laundering and also criminal association. And I noted during my activity, I saw every day all the cases that are arriving in my office. Okay, I say Public Prosecutor Office of Rome, my colleagues, send European investigation order when we have an important case, okay? I don't know, is not exactly correct, but we have this kind of approach, okay? When we have drug trafficking, big drug trafficking, human beings, and or other important case, okay, we have a lot of problem. I think all of you regarding encrypted conversation, okay, with France, Netherlands, and so on, I see that another country, for example, Germany, they send a lot of requests also for small cases. Okay, we carry on also these cases, but I think it could be interesting to have a reflection about that. I know what is the problem of proportionality. Proportionality is not regarding the crime, is regarding the kind of activity, but is a problem. This different approach, and okay. And after that, after this amount, the huge amount of European investigation order that are connected with crime that can produce illicit proceeds, what is the situation? What is the level of our answer regarding seizure and confiscation? What is the proportion? Okay. Well, it's not the same. It's not the same level. We have also in Italy the regulation. It's okay. We are working about on the regulation. Regulation, it's possible. It's possible in all cases that we have in our country, and we have this kind of tools against unlawful proceeds. Okay, it's just I show you. I think you know. Mandatory confiscation for equivalent, confiscation extended on the convicted person's assets, not proportionate to this declared income, and property prevention measures outside criminal proceedings. But the problem is always the same. I said, the level of evidence. In all this kind, the results of our proceedings, national proceedings, are very clear. Our High Court normally said every day that it's important to prove the relation between the proceeds and the crime. Sometimes I have occasion of meeting with colleagues coming from other countries, and we discuss a lot. For example, last week we have colleagues from the Netherlands. Also in France, I think they are discussing regarding new regulation, and they are coming why they is useful for them to see what is Italian experience. And with our colleague, we told them that be careful because this is the key question. Okay, and at the moment, we have this rule regarding the competence to execute certificate. Okay, I don't read. It's very simple, but it's important to note that we need to execute a certificate of freezing. We need a freezing order. Okay, this is important. How many certificate? I am talking about freezing certificate, not confiscation, because confiscation is not, the public prosecutor office is not competent for confiscation, okay? And so we have few cases. But it's not a strange data, because you can imagine Rome is not an area where we can find money laundering from Germany or from Belgium or from the Netherlands, okay? But the problem is not the quantity, the level. The problem is that I noted that these tools is not enough well applied. Okay. Or I don't know if it's possible to read this page for me without the glass. No. Okay. Okay, you can see this is the cases. Okay, from Czech Republic, Portugal, Belgium, and so it can happen. Freezing certificate, but we don't find freezing order. And sometimes, in a lot of cases, we have to send the case for competence, because you remember, not only in the case of certificate, we have 26 public prosecutor office, but we have to send to the competent authority that is not only the 26 public prosecutor office, but the public prosecutor office in the area where the asset it is located. Okay, and so it's a disaster. Rome is Rome, and so I receive a lot of requests, but I have to verify the first thing, obviously. I have to verify if I am competent, and after that, I have to send, and the money disappears. But the problem, we are waiting for a new regulation, and I think the problem is could be overcome. But we can see the problem from Belgium. We have problem with Belgium. EIO transmitted with the request of freezing the account. We find the European investigation order with the request to seize the bank account. Sorry?
Why transmitted to Milan?
No, in this case, because for competence, yeah, because we have to check if the bank account, because we receive the information regarding the bank account, but the bank account is not in Rome. Yeah. Okay, is a big problem, because all these requests arrive without information, without precise information. This is the problem at operational level. A lack of sufficient information before to send the certificate. Okay, And the problem in the most cases without the request to seize transmitted with the European investigation order. The lack of freezing order. Sometimes we find that we receive the certificate and after that a European investigation order is a problem. And this kind of situation is frequent, you see. We don't have any problem normally from France, Luxembourg, perfect, they are perfect. And yeah, sometimes with Belgium problem, and so on. This is the question. And so. Request for seizure of the proceeds of the crime or their equivalent are received. Requests are sometimes included directly in the European investigation order. Rarely is the seizure certificate subsequent to the outcome of European investigation order. For that reason, I said, well, stand European investigation order. Quickly, we make all investigation. After that, direct contact with requesting authority, and we can seize. Okay. Because otherwise it's impossible to seize. It's impossible.
Another opinion yesterday.
Yeah, after we speak about this.
So it depends.
Yeah, no, there is this interpretation from Netherlands, but which was also adopted, was supported by the European Commission, that it is possible to interpret Article 7 of the regulation in the way that the European freezing order itself forms a basis to conduct investigation to all seizable goods in every member state. So this means that it is not necessary an European investigation order that has to be directed to gather evidence and not to confiscate, but it is possible on the basis of the European freezing order, not a specific European to points to specific assets, but the prosecutor in Netherlands has some elements that the assets are in Rome or in Milan. So they send this European freezing order, and the prosecutor in Rome has so the power to investigate. This is the interpretation. And the European Commission supported this.
No, but I agree with you. I agree, absolutely. No, I agree. If we receive a certificate where it's clear what is the problem, what is the crime, where is the bank account or the asset.
No, but the problem is without a specific, only to investigate. Cioè, they know that the assets are in Rome, but they don't know where there is a bank account there. But you can investigate on the basis of this European freezing
completely order. All investigation. It's
this is but the European Commission supported this interpretation. This is interesting because it is a way to simplify. No?
Yes, and we from the Netherlands have requested the European Commission to come with a declaration or a guideline to more specify and clarify for all member states what they have intended with this Article 7, paragraph 1, because in practice we experience that it's not clear for practitioners in all member states. And I think that it's important for the effectiveness of the regulation and the freezing orders that it should become more clear for all countries, for all member states and competent authorities, which what is intended by this regulation and which powers you should have when receiving a freezing order to investigate all assets of the suspect in your country, because we noticed that it's not clear. from the information now in the regulation and the information already provided. So we have requested clarification from the Commission, and we hope they will give some, because they confirmed to us that the intention is that there should be the possibility to initiate financial investigations when receiving a freezing order. But we see that in practice it is not clear for member states.
But the problem is not the form. The problem is substantial, because after receiving the certificate, we have to go to our judge. Okay, and so we have to our judge with the results of investigation. Okay, and but what means investigation? Means that I am the competent authority to ask to the judge the cease. Okay, and in this case I have to identify the assets, the bank account, and identify the owner. I have to discover if the owner is the real owner is a front man, and is not simple, is not easy. Yeah, I can do that with when I receive a certificate, but the problem is the same. The problem is it is not possible to go directly to our judge because we need a lot of investigation. We need a clear situation, okay, regarding the crime on that is on the base of certificate, and after that I have to identify the aim of my request. And we have another problem, because we are talking about proceeds of crime. What is proceeds of crime in my territory? What is money laundering? Because if I have a bank account where I found proceeds becoming from France, from other countries, that are proceeds from drug trafficking, human trafficking, and so on, in Italy, I have a problem of money laundering or reuse. And so in this case, I have also to verify if I have a new of a crime in my territory. In this case, I have to contact the requesting authority to have a contact, and we have to speak about that. For example, if I find that the owner of the bank account is a well-known person in my territory because is involved as a front man in different cases, in web fraud, we have a lot of this situation. In this case, we can conduct another way to investigate, because we can go deeply in this situation. We can discover an organization and so on. In this case, if I open a parallel investigation, probably I cannot seize immediately the amount. I have to wait, but it's not my decision. It's a decision that is after a relation, a discussion, an analysis with the requesting authority. We can choose to realize a joint investigation team. We can notify the case in Eurojust. Every day we have cases like that with the help of Eurojust. Is a great help. And so it is not a problem of a form, is a problem more complex. Yeah, I can consider this perspective, but we have to face on this kind of problem. We are real problem. Okay.
Thank you so much.
Sorry, just
Yeah.
okay. We have. Okay, this is exactly the matter we discussed. It's important. In any case, it's important to you to use to have the help of Arrow. No, it's not common. I discovered that it's not exactly common. Why? I cannot understand. I think it's a problem of training also for police forces. Okay. What is Arrow? Arrow. What is Arrow? Okay, and Karin, the network of Karin, it could be important. Also, the FUNET, okay, it's important, and so I think is a question also to improve, and to have more training for our police officer. And so this is my conclusion. Thank you very much.
Thank you so much for this so interesting presentation to better understand the problems. Maybe there are some questions. Yes, please.
Thank you so much for your presentation. I have just a question that we have this huge problem with the European investigation order phrasing what we are about to do. So I think that from the discussion also with Cyprus, it derives that as long as we don't have interconnected databases with the access to the all bank accounts, it derives the problem that the issuing state does not have the information of which bank account to identify, or maybe they have it, but it's really vague. So maybe they just send this general freezing. You can correct me, but this general, maybe general mention in the certificate, so not specifying the exact bank account. But this, in my understanding, is the burden of the executing state. So we don't have, I think, to put such a burden to the issuing state first. And the second question that derived, it was if Eurojust is ready, and this is a question to you, to manage such central registers of bank accounts, of land registers, because if we think in the perspective, if we start having centralized registers in every country, and after to have them interconnected, and after make central ones, we have to see if Europol or Eurojust could maybe manage them, or which authority would have after access. This would be the problem. So these were the two things.
I would like to respond because member states have, on basis of the European directive, have the obligation to have centralized or interconnected bank registers. And also since 2020, they have the obligation to make sure that all asset recovery officers have access to that information and be able to give the information on the account holders, and if you have a suspect, which bank accounts that suspect has in its name, should be able to be provided via the arrows. And one of the problems you encounter that information is not always clear in the freezing orders you receive is probably because the Italian arrow doesn't have that access yet. In our experience, they don't provide this information on bank accounts yet via the arrow. While in I think except for member states, most member states now are able to provide that information via the arrow offices. So I think it's important that all member states would at least make sure that in a short notice they will be able to distribute this information via the arrow offices, because it is very helpful to make more effective requests to the other member states. So I agree with that.
1 minute. We think big to have one centralized register. At the Article 26 in the new proposal, it was mandatory in the first form to have a national centralized register for all freezing orders and confiscate orders and all assets for each member state. We were only which supported that provision. Now it's another provision which is not, the states don't have any obligation. We all established that we don't have data. The practitioners say this, but I was at every single negotiated time at Brussels, and all the states invoked that it's very expensive. That is the main reason. In Romania, we have this system. It's new. It will be done, I think, from the next month, and it costs nearly 300,000, 405, less than €500,000, which for a state, it's not so much. But the states, the representatives from Brussels, they didn't want it. So we want asset real estate and register for all the European Union, but we don't have it, the national centralized register for each country now. This is maybe tens of years to have it.
This is a political
problem.
decision choice. There is, yes.
It's not like that the Poland don't want this register. We just would like the Commission to give us the money to do it, you know? That we try to force it, like they say that we are trying to make some questions why they would like the countries to pay it. And, you know, it's after that they say that there will be no money. Yeah, we need it, of course. Well, Poland and Slovakia want it, but we want to get the money from the European Union. Yeah. I was on the same company as you, so sometimes.
In Romania was constructed by European funds, this system.
That's great. Why they do not tell that in Copenhagen that we can use Europe? You tell, but the Commission say there is no funds for that.
It said that if we'll have another project, it was in our country. It was on POCA, administrative program. It will become a new, from the new budget of European Union. I think it can be done for each country.
Because we need to like a political issue, we need to have the answer that yes, we will prepare some program for you to get the money to do this, or maybe maybe we can do it. The program that will be good for political issue. We can, you know, come back to Warsaw and say, hey, maybe we'll have money. Let's do it. Let's be on it. But you know, after they say there's no money, I think all of countries which do not have some. That's why we are all against this.
Okay, I give a moment the floor, Professor Erzerbinic. Erberzinik.
Erberzinik, don't worry, it's a difficult name.
Sorry.
No
Please.
Thank you very much. I just wanted to add, because I participated through the whole negotiating process of 2018-1805, and it was not debated in that sense. Nobody even thought that Article 7 would be interpreted in that way. The interpretation of the Commission is interesting, but a certain danger that I see is that you trigger a kind of danger of fishing expeditions. So you are not know where assets are, but then you just send freezing orders to 27 member states, and through this trigger their obligation to do for you a financial search. But it's true what the Dutch colleague said. I think that this problem will disappear soon, at least partially, because there is already this existing directive 2019, I think it's 1153, about access to the bank registers, and there is a new directive just adopted this year that will provide also for cross-border access. So you will be able to cross-border access these central bank registers in other member states. And in addition, the directive I mentioned before on the asset recovery, the new one that is just in the last phases of negotiations or very advanced in the negotiations triggers a very expanded possibility for asset recovery offices. So first, it triggers an obligation to really establish proper asset recovery offices. For example, in Slovenia, we don't have a really functioning proper asset recovery office. So you will have the obligation to have one. And this asset recovery office will automatically or very extensively have already access to data. And then asset recovery offices will be also able to cooperate cross-border to get information. So through this, you will be able to get information that perhaps now is necessary to get by a European investigation order. This I just wanted to add. Thank you so much.
Thank you so
Maybe if I may respond very shortly, because I explicitly don't mean that the freezing order gives room for fishing expeditions. The starting base is that there's a reasonable ground to suspect there are assets in a certain member state. That is the starting point every time. But you can request them to look for other assets than the assets you have seen, or you may have information that there could be assets. For instance, if you send a European investigation order to another member state for house searches, from national experience, we know during a house search, you always find valuable assets as well. Then you can send a freezing order together with the investigation order to, during that house search, also freeze all valuable assets, which you don't know exact which ones will be there, but you know to ask them, if you do this house search, also look for assets to freeze. So the starting point is first to have a reasonable ground to send a request to a certain member state. So explicitly no fishing expeditions, be clear on that.
Thank you. So now, okay, I give the floor to General Prosecutor Office of Bulgaria. Please.
Hello, everybody. Thank you for the opportunity. For those who doesn't know me, I'm Vanya Ilieva, a prosecutor from the General Prosecutor's Office of Bulgaria. We are part of the project from the very beginning, and my presentation. Could you give me the device? Thank you. My presentation is actually an overview of the answers to the questionnaires that the leaders of the project disseminate. So I want to be very brief because the competent authorities, the types of confiscation and the difficulties and so on could be found in the analysis that summarize the answers of all the questionnaires. But I would like to say the following: the presentation and the answers that we gave are always should always be considered as the point of view of the prosecutor's office. Why am I emphasizing to that? Because the prosecutor's office does not have the main role in that activity, but the judges and the court, because only in issuing a freezing order, the prosecutor is the one who initiates that procedure. He went to the court and asks for issuing that kind of order. As to the issuing confiscation order or executing an order from another country for freezing or confiscation, it's always the court who is responsible, and the prosecutor is just part of the open hearing which the court conducts. So I'm very thankful for inviting us to be part of that project, because in my opinion, it helped us to identify some problems that we wouldn't identify maybe, because one of them is the statistics. We cannot have a real picture if we don't have the numbers. And in our country, in Bulgaria, the National Statistical Institute is the one which is appointed to collect that information and to give it to the Commission. When, for the project, we asked for information, we obtained some, but after some questions, what crimes are when we receive a confiscation or freezing order, with what type of crimes are they connected to, and we couldn't obtain a reliable information, because the National Statistical Institute gets the numbers and the explanation from the Supreme Judicial Court and the Supreme Judicial Council, and the Supreme Judicial Council takes the numbers from the district courts all around the country. It's not a big country, but when the systems of the courts is not connected, it's very difficult. So to our question, what type of crimes are behind those orders, we received the following answer. It's infringement of road traffic laws. So there must be some kind of stupidity after those numbers. So to conclude with this issue, the next week, we as representatives from the prosecutor's office and the representatives of National Statistical Institute, we have a meeting which is provoked by this project. So thank you. Maybe we will succeed to make some improvements in this field. So I want repeat again the issues that are in the analysis. We have different terms for confiscation. We have deprivation in favor of the state, the confiscation, which is a penalty in according to our criminal code, and we have the term forfeiture, which is used about the procedure under the law of combating corruption and illegal assets. This law now has a different name, but this is of no importance now. The important thing is that this kind of procedure has been declared by the Court of European Union that it's outside the scope of Directive 2014, and the proceeding is not in the scope of the regulation 1805. But I might be asked why I'm talking at all of this procedure. The reasons are two. The first one is that our government has declared 5 or 6 years ago that the Directive 2014 is implemented in our national legislation, not only by the criminal code, but by that law. And even if by that law, the civil procedure, okay, even if the Court of European Union says that it is outside the directive, I'm not. I don't think that the declaration was withdrawn, and this is some kind of difficulty for me, because the government says this is the way that we implement the directive, but in practice the proceeding after this law is not in the scope of the criminal proceedings. And the other reason is that this proceeding has a practical impact on our everyday life, because being part of the prosecutor's office, I'm more eager to talk about practice and not so much on the legislation, because we are applying it as it is, because the law obliges every prosecutor, when starting investigation about a long list of crimes, to inform immediately the this commission, which deals with deprivation from illegal assets, informs the commission, and they start their civil procedure, which is based only on the difference between the explained wealth and the income of the person. So this procedure is not connected with the outcome of the criminal investigation, and it's totally separate from the criminal investigation. I want to repeat the answers that we gave to the questionnaires. So if you have any questions, I'm ready to answer.
But is outside this model of forfeiture against corruption? Is outside of the directive? Okay, it is clear, because the concept of it is very limited, of non-conviction based confiscation. But is it possible to include in the regulation, because it is always a proceeding connected with proceedings of crime. Corruption is a crime, no? Is in front of, is always with the authorities and judicial authority, or
It is the judicial authority, but it is a civil court, and it is not based on whether the person is convicted for the crime or not. And
this is not a problem for the regulator. No,
Yeah.
in this definition of okay.
No, it cannot be. I double checked with conversation with that commission. How do you execute the court orders when they are concerned? When they concern assets abroad, and they answered, no, the regulation is not for us. We hire attorneys, for example, in Greece, to execute the freezing or confiscation order, and that's all.
But
It's
it's
not
strange,
scope.
because it is clear that the will was to include Italian preventive confiscation. Okay, Italian preventive confiscation is based on the some circumstantial evidence that the person is has committed crimes, but it is not necessary completely, absolutely the conviction. There is not a proceeding in order to establish the liability, the personal liability, but only to establish that the assets have a criminal origin. Only it is dangerousness that meets some suspect or circumstantial evidence of the involvement in activity, in criminal activity, also in the past. But this is an interesting case for me. In my opinion, it could be, it is possible to include. No, but I respect in this, the perspective of the regulation seems, in my opinion, to include, but okay. Now, Netherlands, General Prosecutor's Office.
Yes. So as requested, we just summarized the information based on the comparative chart of the professor. So I will start with just some highlights of the statistics, which are the competent authorities in the Netherlands, which forms of freezing and confiscation we have in our national system, and I will go in a quick way through some problems and good practices. But all information was already given before, so I will not go really deep into all the topics, so we can keep it hopefully a little bit short. From the statistics on the freezing orders in 2021, we received 93 freezing orders from other member states. And we sent 125 to other member states. In 2022, we received 89 and we sent 122. And the last column, you see that the incoming cases we received in these years, freezing orders from 18 different member states. But the most cases we received from our neighboring countries, Belgium and Germany. You can see that in the chart below. And then for the outgoing cases, we have sent freezing orders to 21 different member states, but the most cases we sent to Spain and then to our neighboring countries, Belgium and Germany. And that is because Spain is very popular with our criminals. So we bother Spain a lot with requests on legal assistance. Then with the confiscation orders in 2021, we received 29 requests, and in we sent out 12. And in 2022, we received 63 and we sent out 10. These 2 years are not really representative for the normal numbers in the Netherlands, because I know that before 2021, the average of the cases we sent out is around 30 cases. So these are a bit odd numbers for the outgoing cases. And then incoming cases, the most cases we received from Germany and Belgium. And outgoing, the most cases went to Luxembourg and Spain in 21 and 22. But in the years before, I know the most cases were sent to Belgium and Germany. So again, these 2 years of statistics are not representative of the normal figures we have. And then you can see that in 21 and 22, we received cases from 7 different countries, and we sent requests to 10 different countries. Then the competent authorities for the freezing orders, both incoming and outgoing under the regulation, the requests, the authority that is competent, that is the public prosecutor. So the public prosecutor will recognize and execute incoming requests, and also will draft and send the outgoing requests. And for the confiscation orders in 2020, there was a change of the national law in the Netherlands. Before 2020, the Public Prosecutor's Office was responsible for the execution of court decisions. And in 2022, this responsibility was transferred to the Minister of Justice and Security. So with that change in the national law, also the Minister of Justice and Security became the competent authority to send out the requests under the regulation for enforcement of confiscation orders in other member states. And the central authority for that is an agency which is falling within that Ministry of Justice called the CGIB, which is the National Collection Agency for all criminal and traffic fines and decisions. And then with the incoming cases, the recognition is actually done by the public prosecutor, who is located in the northern part of the Netherlands. And again, because of the change in our national law, the execution will fall under the responsibility of the Ministry of Justice and Security, and the agency, the CGIB, which is national responsibility for the execution of all cases, will also execute the requests from other member states. Then we have 2 models of freezing under the regulation. One is competence of the public prosecution without the need for a prior court authorization. The aim of this freezing is the direct or the object confiscation. In that case, there needs to be a relation between objects and criminal offense. And at the stage of the final decision, the court will decide on the confiscation of these objects. So explicitly will state in his decision that, yes, that bank account will be confiscated. Yes, that house will be confiscated. That boat needs to be confiscated. Then we have Article 49A. Then we need, prior to the public prosecutor is competent to freeze assets, but needs an authorization from a investigative court prior to freezing, and that will be a general authorization that they can, for their financial investigations, in that case, freeze all assets of the suspect. That the aim of this freezing is the value confiscation, and in that case, both the legal and illegal assets of a suspect can be frozen. And in that case also, it will be a value confiscation decision by the court. The court will decide that the suspect has to pay a certain amount of profit he has gained by his criminal acts, but there's not a specific decision of the court on the subjects, the objects that were frozen. So you need to pay a certain amount, but the objects are just a security that this amount will be paid. And in a national system of the Netherlands, it's possible that during the investigative stage, both type of freezing will be conducted at the same time on one object. So if we find an expensive car, it can be both frozen on base of Article 94 and 94A at the same time. Then the models of confiscation. We have the direct object confiscation that can be with or without prior freezing of the assets. That is actually a punishment and will be a decision on the object in the verdict of the court, where there is a relation between the object and the criminal offense. And with this type of confiscation, it's also possible to have some sort of third-party confiscation when the third party acted in bad faith or when there's an unknown third party. And when there's forfeiture without the freezing, the convicted gets an order from the court that he needs to surrender the object. And if he doesn't...
Ja, das ist natürlich eh klar.
Sorry?
Okay. Ja, sind wir sicher.
Okay. And if they don't surrender the object, they will have to pay the estimated value of that asset. And if they don't pay that amount, then there is a possibility of an alternative sanction that the person will be detained. Then we have the value confiscation order. That is a decision on proceeds of the criminal offense. And the court will decide what are the proceeds of the criminal offense. And next to that, the court will also decide which amount needs to be paid by the convicted person. And that can be a lower amount than the actual proceeds. For instance, if the procedure took too long, they can get a reduction of the amount of, for instance, most of the time that will be a standard 5,000 euros that will be deducted if the procedure took too long. And then what I earlier said, there will now be an explicit decision on objects that were seized in the procedure prior to the decision. This is not a punitive measure, but a reparative measure to put the convicted back in the financial situation he was prior to his criminal offenses. And this is a separate decision procedure in the Netherlands next to the criminal case. So at the end of the procedures, there will be two court decisions. One is on the criminal case, the conviction for the criminal offenses, and a separate decision on the value confiscation. They both need to be irrevocable before the confiscation case can be executed. So it is necessary that the person actually is convicted for a criminal offense. Then there is the possibility of extended confiscation in this situation. One is that there can be a calculation of proceeds of other offenses next to the criminal offense that the person was convicted for. So you have proceeds from the offense of conviction. And next to that, there can be a calculation of proceeds for similar or other offenses, which are not part of the criminal offense conviction. And other type of extended confiscation is the calculation of proceeds per period, which is some sort of unexplained wealth decision in the Netherlands. And also in the value confiscation, it's possible to have a third-party confiscation. And for the third-party confiscation, it is necessary that the object has been transferred to a third party explicitly to avoid the confiscation. And the third party has to know, or could reasonably have suspected that this should be that this was the case. So there are some. Not every third party, not every asset that is under a third party can be confiscated in this way. And then the other types of models of confiscation or non-conviction based confiscation we have in the Netherlands. We don't really have a non-conviction based procedure. But we have the withdrawal from circulation that is for objects that have a relation with a criminal offense, but it's explicitly only for assets of which the uncontrolled possession is in violation of the law or contrary to the public interest, and these objects need to be frozen.
Is this dangerous?
Well, weapons, for instance, or drugs. So these type of assets. And it's not necessarily that the convicted owns the assets, but they need to have a relation with the criminal offense. And this is the only form of non-conviction base we have, because the court can also order the withdrawal from circulation when, for instance, there's no final decision on the criminal offenses or somebody will be acquitted, then still the court can order this withdrawal from circulation. Then in just highlights the normative problems we have encountered is the use of the full potential of the freezing orders, especially with regard to Article 7, paragraph 1. I won't go into it because we have a lot of debate on this as well. A restitution of money to victims in case of frozen bank accounts is a real problem in the Netherlands, because in the system we have, the money will stay at the bank. And then we need the cooperation of a bank as well to be able to return this money to a victim prior to a final conviction. So that is a really complicated situation in the Netherlands. And we get many requests for this. So it's under the regulation a real difficult issue. And then also the freezing of assets for victim compensation is a very complicated situation. We get requests which are primarily aimed at freezing of assets for victims. And not always there's a relation with confiscation made in the certificate. We always have to ask the issuing authorities to explain that they can confiscate these assets, and then we are willing and able to freeze them. And if they then requests for some way of restitution or compensation for victims, that is possible under the regulation, but we need this relation with confiscation under the regulation. And then practical problems, we need for effective exchange of freezing orders, it's important to have up-to-date information on assets as much as possible, because that will help quick cooperation between member states. And that means not only information, for instance, on bank accounts, but also the balance of a bank account, because my suspect can have 10 bank accounts in Italy, but if there's no balance on this bank account, what use is it for me to send a freezing order to Italy to confiscate finally €0? Then we have a lot of work and the result is 0, so that is really something we need. Also a problem is the time needed for drafting, translating, sending, executing freezing orders when you have an urgent request. The time we need is still too much, especially when it's about bank accounts or cryptocurrencies, because these values move really quickly and move faster than we can act internationally. So that's a real problem. The quality of the certificate and the use of the correct certificate, I won't explain, my Italian colleague did already. Difficulties in understanding of the communication as well. securing assets in the execution phase is also a problem we encounter. Then maybe for the time I will skip this part because it's already in the national report. So
thank you so much. Only a question. Because there are many models. In the end, there is a non-conviction based confiscation of the proceeds of the crime.
No, we're still working. There's a law proposal in the Netherlands, which is still not formally in procedure. There was a consultation phase of this proposal. But now again, nationally, there is a debate on the actual form and the way we will draft this law proposal. So it's still at the concept stage, zeg maar. So that we're not sure when it will be implemented. But it takes a long time, I think.
Okay, thank you so much.
Sorry, I have also a question for Janelise. Which is the aim of introducing the central authority in this thing? I think I say mutual trust is between judicial authorities, and you have said that the ministry is the authority for executing and using confiscations.
No, but I don't think the ministry should be a central authority. I think it should be a specialized expert authority on asset recovery, freezing and confiscation.
Okay, not the Ministry of Justice.
No, a specialized expert group.
Okay, thank you.
For instance, an arrow or something like that.
First, I have a question because you say that the money stays in the bank account, like in the bank, the same as in Poland. And how do you handle the situation when you have a lot of frauds and all the money gets into one bank account and the victim comes to us and say, oh, in these accounts are my money. And for example, she said that the fraud was about 30,000 euros and you have 35,000 euros in this bank account, but you know that they are from all of the different frauds. Do you get the money back to the victims and left on the bank account 5,000 euro, and how you handle it? Because we have a case in Poznan which was that, and we don't know what to do. And there's no judicial about it, and we say that no, we cannot give you the money back. We need to wait for the end of the investigation and then to just give the proportionality of the money to all victims.
Well, actually, in the national cases, we will not return money that is in bank accounts to victims. Normally, nationally, we would use this procedure only for assets that are taken into custody of the Public Prosecution Service. So it could be we seize a car which was stolen, and then a victim comes and says, this is my car. We can take a decision to return that car to the victim. In international cases, we try to cooperate as much as possible when we receive a request, but then the simple ones will be that there's one transfer of a victim to a certain bank account, that amount is actually frozen in the bank account. We see in the transactions that this was transferred from the bank account of the victim to the bank account of the perpetrator. Then we can act and try to get cooperation of the banks to return this money to the victim. But in the situation you encounter where there are multiple victims and there's not enough money to refund all the victims, then yes, we have to wait to a final conviction. Yes.
For the second one remark, can I be next because I have a flight today too? Okay, thank you.
Sorry, just a quick one, Annelies. What do you mean when you say get the cooperation from the bank? What is the margin of the bank to say, no, sorry, I'm not releasing these funds now?
Well, actually, I think at this moment,
argument?
nationally in the Netherlands, they have the freedom to say in all cases we don't do it because the legislation we have is for returning money of returning seized assets to other persons than the one it was seized under. Explicitly is aimed at the objects we actually have in our custody. So we try to extend it as much as possible to also bank accounts when you have fraud cases, because it is really in the interest of victims to have their refunds as soon as possible. But banks are not legally obliged to cooperate. So they will only cooperate if they see it's a clear relation between the amount of the fraud and the amount in the account. And only in those cases they will feel the freedom to cooperate to our request to act.
And to add on that, sometimes you see the mechanism that banks like to have a waiver of the public prosecutor's office in some sort, so they don't get to deal with claims of different persons contractually or civilly, in order for them to persuade them to cooperate. So there are two systems going on, one criminal system, and the other is their contractual obligations they have. And of course, the due diligence they have with the know your customer procedures they need to follow. So it's a bit complex, and to be on the safe side, they usually want a written declaration or something from the prosecutor's office, and to be absolutely sure that they're entitled to forward that money to a different bank account. But it's a topic, like Janelise said already, that we need to work on in legislation forms.
Okay, yeah, that makes so sense.
Minister of Justice?
Yes. Przemysław Szymański, Minister of Justice. I try to be as brief as possible. On the last VTC, we just gave you an idea about our form. So maybe today I will try to say more about the confiscation in Polish criminal law. First of all, I would like to say that we do not use the word of confiscation. We just use the word of forfeiture, and it's not because it's basically the same. But in the People's Republic of Poland, there was something like was a confiscation of property, and it could include a lot of part on convict person, everything that belongs to him. There was no timeline, nothing. It's everything belongs to him, could be taken, and it's only based on irrefutable presumption, no the judgment, only irrefutable presumption. So that was a very negative historical. The confiscation is very negative in historical, so we don't use it. Yeah, it's why we name it forfeiture. And only nowadays we use like extended confiscation, but only in legal language. And it's not like a popular, but in legal language you use it. Yeah. Okay, so we have a lot of different term of forfeiture. There are forfeiture of object directly derived from a crime, forfeiture of object that served or were intended of the commission of the crime, forfeiture of object prohibited for manufacture, possession, transmission, etc. by the law, forfeiture of equivalent of object directly derived from the crime or object that were used or intend to be used of the crime, forfeiture of a share in co-ownership belongs to the perpetrator, and then we have a forfeiture of equivalent of a share in co-ownership, and it's something that we used more than forfeiture of the share in co-ownership, because in Poland we try not to, when there is co-ownership, we try more to get the equivalent than to sell the co-ownership belongings. We have a forfeiture of company, and the same here, we have a forfeiture of the equivalent of the company. Here as well, we try not to forfeiture the company, try to get the equivalent. If no, then we try to forfeit, there we need to forfeiture the company. Okay, I will make it more briefly, so I skip it. Okay. I think something what is very important that in Poland, it's possible to make the forfeiture without convention for all of these types that I tell you here. So we have a 7 and all of them can be like without convention, not non-convention based confiscation, but there are some excluded. Yes. In certain cases, may apply extended confiscation or all other confiscation, but negligible social harmfuls or a criminal offense must be the fact that the suspect or accused person committed a criminal offense in state of insanity, so he don't know what to do exactly, or during probation instrument of conditional discontinuation of the criminal proceedings. So if we discontinuation the criminal proceedings, And when the death of suspect or accused persons where, and this is very interesting, when discontinuation of criminal proceeding due to failure to detect suspect or accused persons. So when we do not have suspect even, but we know that there is some money, for example, and we know that we have a certainly true that there is from the fraud, for example, we can make a forfeiture about this. And yes, and we will have maybe something that's different. We'll have a new one type of confiscation. We say it's forfeiture, but it's a confiscation. We'll confiscate the car for drunk drivers. Because we have a lot of problem with that in Poland. So we think that this is a new regulation. It will be on March next year. It will start. So when you will be a drunk driver, after, and you even if you do not commit another crime, like the accident or something like that, just you need to be drunk driver, we will take your car or the count of the car, because there is some situation when the husband and the wife have the one car together. And we cannot punish the wife that the husband or was a drunk driver. So the amount of money of the half of the car he need to pay to yeah. I think that's all. If you have some questions, you can ask. If not, because everything is on the form. So even after the meeting, you can just text me and we can talk. Basically, that's not a problem. Thank you.
Okay, thank you so much. There are some questions. So I remember that you have to deliver the questionnaire, the feedback questionnaire. It is very important. Thank you so much. Now, Romania Asset Recovery Office. Yes.
Thank you. Our presentation will be a brief one. Of course, in Romania, we have the special confiscation, the extended confiscation, non-conviction based confiscation, which can apply as a special confiscation. And also, we don't have any confiscation in a civil matter. In REM, we don't have the problem as we talked about yesterday. The legal nature of the confiscation, it's a security measure, and this is why we can confiscate in the non-conviction based confiscation in criminal field. I will say it again. Maybe we can change something at the directive, because it's not done. Unfortunately, the obligation to establish a national register of all freezing and confiscation order has been rejected by most of the members, as I said, that the Article 26 in the new directive. Romania is currently implementing a unique electronic register called ROARMIS, Romanian Asset Recovery and Management Integrated System. It will contain real-time data on freezing and confiscation orders. In addition, the system provides for efficient management of freezing assets. At the same time, the system will make it easier to identify assets that have been made frozen or confiscated following the recognition procedure in the regulation, as it will be function to identify files with an element of extraneous. We presented this system at the meetings held in Brussels when we negotiated the confiscation directive. However, the creation of such an electronic register must remain a possibility. So it's remain a possibility according to the majority of the states. I only say something about our role in the regulation, because we also spoke about the AIU, about the different types of confiscation. but we can also speak about the role of arrows. So in Romania, we have three competence in the as an arrow in the matter of the regulation. First, during the investigation phase, ANABI, which is the arrow and AMO from Romania, Asset Recovery and Management Office. So ANABI provides information obtained through police cooperation, which can either be used directly as evidence or can form the basis of the European investigation order at a larger stage. As I said, the new proposal, Article 9, Paragraph 4, can, if it will be modified, can be mandatory to use that information as a proof. Now it's not mandatory. The states can refuse this aspect. In the originally form, it was mandatory, but now this information can be used to police cooperation as intelligence to make start an European investigating order, or if the state is okay with that, can be used also as a proof directly for emitting a freezing order. Based on the evidence obtained, the competent authorities issue and recognize the freezing order in accordance with the regulation, which is the first competence as an arrow. The second competence is during the enforcement phase. ANABI has the power to submit the matter to the execution court regarding the procedure for recognition of an equivalent confiscation order, special or extended confiscation order. So after in the national field, we have a confiscation order. It is transmitted to us after we executing the assets on the national level, and we see we have a debt, a big debt, and we have some information about that the person, physical or legal person, have assets on European countries. We go with requests on our judge, the executional judge, and he can start the procedure from the regulation to recognize in the other country the national order, confiscation order. But the national judge will not know about the level of the execution if we don't provide him some information. So this is our job to see if it is necessary to determine such a cooperation after we have a confiscation order. And the third competence, it's that ANAPI has the legal authority to negotiate and facilitate the conclusion of asset sharing agreement. So after the other state, the executing state, will execute and establish the money, from our state, from Romania, we are the entity that can negotiate the percent, or can be 50-50, which is mentioned as normal in the regulation, or we can negotiate other percent. When concluding asset sharing agreements, ANABI in most cases apply the general principle of equal sharing, which is stipulated at Article 30. According to this principle, if the amount obtained from the execution of the confiscation order is equal or to or less than 10,000 euro, it will revert to the state, requested state. If the amount obtained from the execution is more than that, we will apply to the requested state. Some conclusions about Recover project. We believe that the exercise, this exercise we are undertaking, the Recover, should be extended to all member states. Firstly, there would be a database of the confiscation models which are in place at each state level. Yes, the existence of, but we are 10 we are 10 states. We need 27. For every. It will be great. Okay. The existence of peculiarities in relation to different types of confiscation model determine most of the problems. Secondly, analysis of the whole system will be carried out. This will help to identify concrete solutions for the future. For example, to the fact that Romania did not have any files in which it had the status of requesting state in the case of confiscation order, the institutional mandate of ANABI was extended in 2022. In this sense, ANABI acquired the competence to notify the executing courts to go through the procedure of recognition of the confiscation order, as I told you, is the second competence in that matter. Finally, we hope that more member states will join this effort, thus creating a real European network of practitioners in this matter. Thank you.
Thank you so much. In our research, we are trying also the unit of Catania, the transcrime with Matteo, and also Anna, the Humboldt University of Germany. We are sending a questionnaire to expert, academic, and practitioner, and we are getting these questionnaires, and also we are interviewing academics and practitioners for each member state. It is not so easy to find people available, but we are trying. Yes. So the idea is to get information not only from the partners in the project, but also to have a survey of the situation in Europe and also in some other countries out of Europe or country we don't adopted the regulation, like Ireland or Norway. And so now I give the floor to Lithuania, General Prosecutor Office. Is that?
Oh. Mm-hmm.
Okay.
Okay.
Thank you so much.
I think you can see me. You can hear me. Yes.
Yes. Yes.
Yes. Yes. Could you please show my presentation, because last time I failed and this time I'm not sure if I'll manage, and we have a tense time, so it's better to interact with you. Thank you, Anastasio. So first of all, thank you for, I would like to thank you. Very, very nice event, very fruitful, very useful for me. I also fill in the form of survey, gave highest results. So thank you so much. I very appreciate problematic about models of confiscation, and also I very appreciate idea which was said by Ms. Fonte about problems and about how to find out how to solve situations with beneficial owners. And what regards Lithuania, it is important for us to know. I would like to share the good news, and this good news is for whole Europe, because there is a directive from 2013 slash 1132 directive relating to certain aspects of company law, and this directive obliges to all member states to have registers, not only bank accounts, but also registers about companies and about beneficial owners. And what is good that this is an obligation to have European Central Platform, and should be established, and this system should interconnect databases of all member states. That means that we all are going forward, we becoming stronger and stronger. And what regards Lithuania, we have register of beneficial owners, and we are in process of obtaining system, the link to European Union, and to be together in one swimming pool, informational. So also I would like to share, since I during this event found out that there was a problem about beneficial owners, that this directive for 2015 849 on the prevention of use of the financial system for purposes of money laundering. And in this directive is a definition about beneficial owner, and there are criteria who is beneficial owner. That a person who controls legal person or natural person, who owns 25 plus 1 shares, and so on. So this is provisions of directive, and these provisions should be in our national law. So I think it's also the awareness of this will promote our asset tracing when we talk about companies, when we talk about criminals who hide their assets in the companies. And I also see good and nice future and our power together. So if we had some presentations last year, this year in the beginning, then this other workshop. I'm not going to talk too much. I will tell briefly, because agenda says that I have to talk about this. We have, I think, all the models of confiscation, classic confiscation, also extended confiscation, and these models of confiscations also has direct confiscation, not direct confiscation, confiscation of the value against third parties. So we also have non-conviction based confiscation. What regards non-conviction based confiscation, this supervision is in CPC in Article 94, which obliges us to confiscate when we terminate a pretrial investigation and or terminate a criminal case in the court. And we also confiscate property when there is statute of limitations, when there is death, and we have legal practice. We also have decisions of our Supreme Court, and our doctrine is pretty clear. So next slide, please. So also, I think that other forms of release from criminal liability also go into the scope of non-conviction based confiscation, because we can confiscate property when we release persons from criminal liability, when they lose their dangerousness due to minor relevance of a crime, due to reconciliations between offender and the victim, also on the basis of mitigating circumstances, also when people from organized groups help for investigation, and if there are grounds to release them from criminal liability, but this doesn't mean that their assets are not confiscated. Also, by release from criminal liability on a bail. So, what regards law on civil confiscation, next slide, please. When was the first workshop, we discussed about this, and I'm not going to take your time, but I would be very happy to have a possibility after my presentation to give a question to Professor Anna Maria Mogeri. I would like to have consultation because we had discussions in our prosecutor general office, and it won't be not sensible not to use this opportunity, and I'll tell the situation in the end of my presentation. Next slide, please. So colleagues from Holland from yesterday told about problems with Lithuania, that they face burden when they have situations with Lithuania, because they have to prolong terms of freezing. So this is it. Our country has provisions in the CPC code, and these provisions you see in the screen. Freezing can be done only for 6 months by the decision of prosecutor. Then it can be prolonged only in the court by pretrial investigation judge. And if crimes are not serious, it can be prolonged not only for 6 months, and if crimes are more serious, if there is a civil claim, or if suspect absconds, these terms can be prolonged without limitations. But yes, this is provisions, and we have to follow it. And when we have situations with the freezing orders according regulation, we also, Lithuania, have the same burden. And our burden is even higher, because we are these prosecutors who have to follow these terms and to apply to the court in time and not to omit these terms. So yes, this is specific, but law is law and nothing to do. Next slide, please. So I think maybe this slide is not directly related with our topic, but I think this slide shows how important is cooperation and how important is our project, because we see, according statistics, all investigation orders numbers are rising dramatically. This means that we'll have to trace assets also more proactively because there are no borders between the crimes. Next slide, please. Yes, this slide was showed in previous workshop, and you see the numbers of incoming and outgoing orders, freezing orders in prosecution office. And last time I was asked why there are so discrepancies between incoming and outgoing freezing orders, and I couldn't answer you, and this question was very good, and this thank you for the project. And then I showed this, discussed with our colleagues, with my superior prosecutors, and we talked about these numbers, and we have to check the situation, but one of the reasons is we came into conclusion that Lithuania is becoming of a hub of fintech. That means that there are many financial institutions of fintech, many companies, and this means that there is flow to Lithuania. And this means that demand of freezing orders in Lithuania is also very, very high, because the freezing orders in Lithuania are mainly in relation to bank accounts and to money, also virtual currency. Next slide, please. So this is confiscation orders, data from courts. Next slide, please. We are going to problems, to issues, and issues are traditional. First of all, Lithuanians is official language. And we get freezing orders not in Lithuanian language, sometimes not even in English language. Sometimes they are technical mistakes. Maybe these mistakes are not so relevant to our project. This is human factor, and this is not scientific value of this to pointing out, but we face these problems, but we have consultations and we solve these problems. Yes, but they just eat our time, and while we sort out these problems, money can escape from bank accounts. Next slide, please. Also, I found, I interviewed colleagues, many of them, and they told me that was also some technical problems about decisions were not attached, also failure to keep tracking deadlines and inform prosecution if extension of the assets freezing is still relevant, and also once we freeze assets in bank accounts, we check some balance and find out that the balance is poor, no many money is left, and we try to consult whether it's relevant and not always get the feedback. And the main problem, the main issues, because these that were mentioned above, they were technical, and when we go to article number 29, which sets out restitution, we get also from member states to restitute money, and we not always get not always get information is sufficient that all requirements of Article 29, paragraph 2 are met. Especially, we find out that issuing authority don't prove that the decision about restitution was sent to parties which are affected, and once we start procedure, we find that these provisions are not fully, and then we stop, and there are some practical problems. And the last practical situation was regarding civil confiscation. We had one person who was acquitted of a crime of corruption, and his property, we found out, was not within legitimate income, and we started procedure of civil confiscation. This procedure was made on the basis of evidence that was collected in criminal case. And then we had sufficient information that this person has a property in other member states. And we tried to find his property in this other member state, and we wanted to try to have practice, to have a test case, and the prosecutor who had this case came to me as arrow contact point, as carrying contact point. And I, using arrow channel, contacted this member state for consultation if it's possible to make procedure and to find this property, and then to initiate freezing and following procedures. And no answer was given. and I wrote several letters, contacted, but no answer was given, and we gave up. We thought it might be, this happened before this project, and this it wasn't discussed as now within this project. And we gave up. We thought that because we thought that it doesn't go into scope of regulation. And now during this project, I'm thinking that we made mistake. So the question is, what is your opinion? Could we go further? Could we go within the regulation? This. So thank you. I would very appreciate your answer.
Okay, so in my opinion, yes. Because if I don't have, if I don't made a mistake, is a model still civil confiscation is always a confiscation of a proceeds for crime. Yes.
Not proceeds of crime, unexplained wealth. It's
Yeah, unexplained wealth, but because this there is the suspect that is proceeds for crime.
Yeah.
Yes.
Yes.
And the judicial there is a judicial authority. It's a proceeding in front of a judicial authority.
Yeah.
Yes.
Yes,
Yes.
because criminal case and this investigation, financial investigation within the framework of civil confiscation was made by law enforcement agency, by financial investigation service.
Yes, but is a financial investigation authority, but is there a proceeding in front of a judicial authority?
And the Prosecutor General's office was controlling, supervising this investigation. The investigation within civil procedure was conducted by law enforcement agency, but supervised by Prosecutor General's office, prosecutor.
And so in the end, the confiscation is adopted by the prosecutor, not by, or by this agency, enforcement agency, and not by judicial authority.
No, we gave up because we didn't go further. But according to our
No,
law,
but normally in the system, which is the rule.
normally the system, well, once we find that it's not legitimate income, then prosecutor writes this claim and goes to the civil court.
Yes, so in the end, there is the judicial authority.
Yeah.
So the problem this only problem. In my opinion, this is a proceeding with a link to a crime, because it is a proceeding in any case. In the end, the order is adopted by a judicial authority. And is adopted because the assets are confiscated because they are considered in some way profits of crime, proceeds of crime. So in this extended the concept of a proceeding criminal matter, they are included. The problem is if the essential safeguards which demands the regulation are recognized. And I have only a doubt about the fact, is there a reversal of the burden of the proof? Because in the regulation, in the end, there is always the idea that it is not possible to admit a absolute reversal of the burden of the proof, but the enforcement, the judicial authority, the prosecutor in this case, has to demonstrate also with the use of a reputable presumption that there are on the basis there is the specific rule in the regulation that the legal origin. So and also in all the instrument that today I speak about, articolo 8 of the directive, articolo 33, and articolo 88 of the directive, no, specified that the affected person should have an effective possibility to challenge the circumstances of the case. So the regulation is not so clear, but it speaks about essential safeguards of a criminal proceeding. So essential safeguards at least means that it is not possible to adopt the absolute reversal of the burden of proof, but that in any case the prosecutor has to give some evidence also with a lower standard of the proof, and the owner can try to demonstrate the legal origin. So in my opinion, it is possible to include, but the only issue is that it is not possible to accept an absolute reversal of the burden of the proof.
Okay. Okay, thank you.
Also, if the regulation is not so clear about the essential safeguards, but the regulation said that the procedural rights which are recognized in the directive about the presumption of innocence should be applied. In this directive, it is affirmed that it is possible also in criminal law to adopt presumption, but only reputable presumption. And in any case, the right of silence must be recognized. So on the light of this directive, in my opinion, it's not possible to accept an absolute reversal of the burden of the proof. This is okay. Thank you so much for your presentation. And now we have Portugal. Is there Portugal? Yes.
You should switch on
General
the microphone.
Prosecutor Office.
You are authorized to do so.
João Correio. João Conde Correio. You have to turn on the microphone. Sí. Yes.
Oh,
Oh,
no.
yes, you are.
Can you hear
we
me?
can hear you.
Oh, sorry. Technical problems.
No, don't worry. We see only your eyes.
Oh.
Wonderful
now?
eyes, but it is better to
Now it's better. I
see
can always put a book.
all your face.
Yes, I can always
Your
put
wall
it.
face. Okay.
I send one PowerPoint. Can you share the PowerPoint, please?
Yes.
I sent last version today.
Yes, it's the last one you sent. Thanks.
Thank you. So thank you very much for giving me the floor, for giving me the opportunity to speak in this wonderful event. Good morning, good afternoon, everybody, for those who are in the room and for those who are online. First of all, I have to apologize. Yesterday, I was not able to attend the meeting because I was in Brussels at the 25th Asset Recovery of Platform meeting. For me, it was impossible to fly to Milan, to be in Milan. But today, at least, I can participate online. Uh, Actually, even if yesterday I was not here, we have in Brussels a very interesting presentation of the project Data Cross Second, made by Antonio Bossicio from Transcrime. So, in a way, I was also with you. My presentation will be very short because I don't have news. And the practice in Portugal is, if I can say for one hand, is very poor, and from the other hand, it's the answers are already in the questionnaire. So I will be very short. First slide, please. Before really beginning, allow me just two small comments. The first one is one comment into the first part of the comparative chart. The Portuguese the law provides for different models of confiscation. Direct confiscation, it means the confiscation of instrumentalities, products, and proceeds from crime. Value confiscation, it means the confiscation of an object, the confiscation if the object is not available anymore, or if it is a value. Unexplained wealth confiscation, third party confiscation, and non-conviction based confiscation, and finally confiscation in administrative penal law. That is outside the realm of criminal law, even if it is intimately related with him, but this is outside the criminal law, so it's outside the regulation. The problem is, from my point of view, that Portugal doesn't have the so-called extended confiscation, as I think we point out in our first questionnaire. What we really have is unexplained wealth confiscation that is better placed in the last column than in third column, as it is in as it is in your work. So it is not, as it is there, so-called unexplained wealth confiscation as it is in the chart, but so-called extended confiscation. So the legislator call our regime extended confiscation, but in reality is unexplained wealth confiscation that is, from my point of view, is a totally different concept. The second comment and third slide, please, is that after answering the questionnaire, I discovered that the European Commission is now threatening Portugal with an infringement proceedings because Portugal doesn't have statistics on this field. In fact, in Portugal, this is not possible to collect a complete and very reliable statistics. There is no authority in charge of collecting all this data. The ARO has its own data, the Public Prosecutor Office also has some data, and finally, the Judiciary has some data too. So if one doesn't join all these statistics, there will be the risk of missing something. But if you join all together, you can also count twice or more than that. This is a very serious problem, like Professor Savona pointed out this morning. We cannot speak about what we don't know. We can speak theoretically about the regulation, about the directive, but we cannot speak about the practice. And more than that, the problem is that one cannot intervene amending rules if one doesn't know what is going on the field. Third slide, please. even so, we can say that our main problem, or the main problem, is the lack of knowledge. The lack of knowledge. If the law enforcement authorities don't know the importance of freezing and the confiscation at national level, how are they going to do it at international level? How are they going to do it abroad? So we need training. We need training. Training at national level and also training at international level. And this is not, we can see for this seminar, this is not only a Portuguese problem. For instance, during this morning, we spoke a little about the distinction between the application of the regulation and the application of the European investigation order. Also, here in Portugal, we received some European investigations orders in order to freeze assets, not as evidence, but to freeze assets in order to confiscate. And so this is a problem, not only a Portuguese problem, but also perhaps an European problem. The same happens with the Spanish colleague and also with the Italian colleague that pointed out this problem. Also, this morning, Mrs. Susanna spoke about the numbers of Eurojust that are growing, but I think much more needed to be done in order to show that the crime doesn't pay. We have to bear in mind that on assets recovery, or assets recovery needs more international cooperation than cross-border crime. Why? Because even in a purely national crime, the assets can be abroad, and to return that to our country, we need international cooperation. Next slide, please. The one Portuguese proof of the lack of knowledge is perhaps the lack of appeal decisions. In Portugal, there are 5 courts of appeal, which decisions are almost all published online. So I searched for the decisions about the regulations, and I only was able to find one decision from a civil court that quoted the regulation, but was not about the regulation, because it was about the enforcement of a very old confiscation decision taken many years before the regulation. So this is for me something strange, because we should have now some Supreme Court decisions or appeal court decisions, and I was not able to find one that regarded to the regulation. Next slide, please. Next one, please. Even if it is for me very hard to speak about what I don't know. The answers to the answers that we get from our colleagues, we can they spoke about some kinds of problems. One problem is relating to the return of property assets to the victim, or some problems are relating to the return of assets to the victim. I think the other colleagues also spoke about this. There is in certain cases not clear what is the return of assets that belong to the victim, like for instance a car, and in which cases we should share the assets that are confiscated. We have one case where someone stole 10 million of jewelry in Portugal that were later found in another member state. This is like the example of the car. But the problem is that they are now demanding a final decision, and they are saying that we have to share the product of this, we have to share this jewelry. I think this is not acceptable, because this is not a case where we have to share. This is a case where we have to return all the jewelry to the owner. Another problem that seems to arise here is how the costs should shared when the seizure is sent to another state in order for the property to be returned to the victim. It is also another problem that the colleagues reported to us. Next slide, please. Finally, we have also a problem when the goods are in a different location. For instance, we can receive, for example, a freezing order, but the goods are located in the north of Portugal, one house, for instance, and another house in the Algarve. In this case, there are different locations, there are different judges. We can have problems here. Perhaps the problem is that in Portugal we only have the regulation. We have not an internal law, and perhaps if we had an internal law, these kind of problems could be solved very easily. Next slide, please. So for the moment, this is what I have to say from Portugal. I know that it is very poor indeed. It's a very poor situation, but we don't have the knowledge, enough knowledge to say something more important. Thank you very much.
Thank you so much. It is not true that this is so pure, but because also from the questionnaire we have an important indication from Portugal, by Portugal, and in any case the problem of the training is a fundamental problem. Each partner has stressed this problem, this general problem. Okay, thank you so much. And now I would like to give the floor to Professor Bosch from Norway. It is a country which is not covered by the regulation, but it is always interesting, in our opinion, to understand which are the possibility of cooperation for the fight against organized economic crime through the instruments of confiscation, freezing order and confiscation. Thank you so much for your participation. I give you the floor.
Thank you very much. My name is Johan Bucht. I'm a professor of criminal law at the Norwegian Business School, BI, in Oslo. I was wondering, I did send you a PowerPoint presentation.
Yes, we are projecting it in our screen. You should see it.
Excellent.
Thanks.
Thank you. Yes, so I interpreted my mandate as to say a few words about the Norwegian confiscation regime. I would therefore not present any statistics about the number of requests abroad, or the more specific statistics about the amount of confiscation orders within Norway. Next slide, please. So Norway is not a member of the EU, but is a member of the EEA, and as such, it's not bound by the EU's confiscation regime, and that also includes the 2018 regulation. It also includes for example, the 2014 confiscation directive. However, there has, as I understand, been some discussion in Norway whether or not Norway should join the EU confiscation regime, and perhaps that would not be such a bad idea after all, particularly considering what we've heard also today, that criminals have a tendency of placing their assets abroad. Next slide, please. So in Norway, the confiscation regime is mainly conviction-based. In other words, confiscation is, as a rule, contingent on the existence of a criminal conviction. Non-conviction-based confiscation is not explicitly recognized in law. However, there has for a number of years been a discussion about the introduction of such rules. And the government has now promised in its manifest to also introduce non-conviction-based confiscation. The discussion has centered around whether or not a civil recovery scheme, such as the one you find in the UK or Ireland, should be introduced, or whether you should use a more hybrid scheme of the kind you find in, for example, Germany, which is located within the criminal domain, but is still non-conviction based. Now, the Justice Department recently appointed myself as the chair of a committee to finally explore these possibilities and to come up with a proposal for the government regarding which kind of non-conviction-based confiscation scheme Norway ought to adopt. The deadline for our work is the 31st of May, so hopefully we'll be able to present a decent proposal by then. Neither do we have any explicit unjust enrichment mechanisms, neither of the kind that you find in the UK, for example, as investigation orders, or as you find in some other countries where you can simply confiscate the assets which are disproportionate to the individual's legitimate income. So the main rule is conviction-based. However, there is an important distinction made between the confiscation of proceeds of crime and the forfeiture of instrumentalities. Now, this terminological distinction, forfeiture and confiscation, is not as such utilized in law. It refers to confiscation of both kinds, but for clarity, I prefer to distinguish between confiscation of proceeds of crime and forfeiture of instrumentalities. Next slide, please. Now, regarding confiscation of crime proceeds, we have two different kinds or two different schemes of confiscation. The purpose or the objective in Norwegian law of the confiscation of criminal proceeds is to restore status quo ante. In other words, this is a backward-looking instrument which seeks to achieve gain neutralization. The Supreme Court has, in a number of cases, said that the justification for confiscation does not extend further than to restore and to take away from the criminal what he ought not to have had in the first place. Now, the first kind of confiscation, and perhaps the most important one, is what you can refer to as regular criminal confiscations. It's under Section 67 of the Penal Code. Now, this means that this is a mandatory form of confiscation, which requires the courts to confiscate, provided that the provisions or conditions are satisfied. Only assets connected to an offence for which there is a criminal conviction can be confiscated under these rules. In other words, there is a requirement of causality between the assets and the offence. Confiscation can be ordered based on the actus reus of the offence. This means that no mens rea is necessary. In other words, confiscation can be ordered even though the person has not displayed the necessary intent or negligence, or if the person is a minor, or if he cannot be convicted because of mental capacity. So, provided that the objective elements of the offence are satisfied, confiscation can be ordered. Now, confiscation can be ordered both in specie, in other words, of the assets as such, for example, a car, or in value. In other words, if the person, for example, has obtained a car as payment for narcotics and then sold this car, then you can confiscate the assets or the value instead from the individual. Now, the burden of proof is beyond reasonable doubt as regards the conditions for confiscation. However, when it comes to quantification, in other words, for establishing the amount or the confiscated amount, then the standard of proof is lower, is then the balance of probabilities. So Norwegian law here operates with two different kinds of standards of proof. In other words, the ordinary criminal standard and the lower one, the balance of probabilities. Next slide, please. Oh yes, I should also mention that third-party confiscation is possible under Section 67 if the criminal has handed away the assets to someone else. They can be recovered from this person either where they were given as a gift. In other words, there was no value for the transfer, or where the person, the receiver or acquirer, was in bad faith. Now, the second kind or category of confiscation scheme relating to criminal assets is Section 68 of the Penal Code, extended criminal confiscation. Well, as you probably all know, extended criminal confiscation enables confiscation of assets which cannot be linked to a particular offence. So in other words, here we have a trigger conviction of a particular offence, and where this trigger conviction is in place, then you can confiscate assets that go beyond assets that can be linked to that particular conviction. Now, in Norwegian law, the trigger can be either a single offence, provided that it carries a sentence of 6 years imprisonment or more, or it can be 2 or more offences, provided that they've been committed during the past 5 years and they carry a prison sentence of 2 years or more. Now, on top of that, it's required that the offences are of a nature likely to produce considerable economic gain. It's not enough that they're liable or likely to produce gain. It has to be considerable economic gain. Now, in this case, the Norwegian law utilizes a reversed burden of proof. So here the burden of proof is reversed onto the defendant. So he or she has to prove the legal origin of the assets in question. If he or she cannot do that, well, then the assets can be confiscated. Potentially all of the defendant's assets may thus be confiscated, but so far the Supreme Court has normally restrained itself to only confiscate in certain or a smaller part of the defendant's assets. Also in this case, both in specie and value confiscation is possible. Next slide, please. Now, the Norwegian regime for the confiscation of proceeds of crime has a very wide scope as a consequence of 3 concurring aspects. And the first aspect is that the offence of handling of stolen goods is a very wide one indeed. And the particularly one aspect is relevant here, and that's that the predicate offence does not have to be proved. In other words, it suffices that the person holds property that stems from some criminality. Now, secondly, that the facct that the actus reus of the offence is sufficient for confiscation that I mentioned earlier. In other words, it does not have to. The prosecution does not have to prove mens rea in order to confiscate. It's enough that the objective elements of the offence are in place for confiscation to take place. And thirdly, confiscation is, under Section 74 of the Penal Code, also possible where the perpetrator is unknown. In other words, there is a particular procedural rule in the criminal code saying that even if we do not know who the perpetrator is, but the conditions for confiscation are otherwise satisfied, then we can confiscate. Now, if you put all these 3 together, then although not recognized in law, the existing powers are not a very far cry from both non-conviction based confiscation and an unexplained wealth mechanisms. It can also be pointed out that confiscation can be ordered both by the courts and by the prosecutor. And in the latter case, obviously, it may then very well be that provided that the defendant does not complain to a court, that the confiscation measures actually go without judicial oversight. Next slide, please. Right, so that about confiscation of proceeds of crime. Now, the second category is the forfeiture of instrumentalities. And this is referred regulated in section 69 of the Penal Code. Now, in this case, the purpose is mainly preventative, in other words, forward-looking. The idea here is that you wish to prevent the commission of further offences by forfeiting the property in question. Now, property that can be confiscated is property connected with an offence in some way. Also here, it's conviction-based, so there has to be a conviction for that particular offence. The property in question can be, for example, instrumentalities, in other words, property that has been used to commit the offence, or the object of a criminal offence, for example, the assets in money laundering. Now, the third category of confiscation measures, or the third confiscation scheme that we have in Norwegian law, is what is called as preventive confiscation. That's in section 70 of the Penal Code. This is a particular kind of confiscation in that it is not conviction-based. And no conviction is required. The measure is strictly forward-looking. The point here is that property may be confiscated if there is a considerable risk that it will be used to commit an offence. And this provision has not been used or is not very frequently in use, and it's not really been used to deal with economic crime. Traditionally, it's been used in order to prevent, for example, violent offences from being committed, where you find guns or other kinds of objects that can be used to commit violent offences in a particular environment, say, for example, within a motorcycle club or in an environment where crime is often committed. Then in these cases, that property may be confiscated. It's doubtful if, for example, cash can be confiscated under this provision. So in this sense, the notion of preventive confiscation, I think, is quite different from the notion of preventive confiscation under Italian law. Now, even though particularly the rules on confiscation relating to proceeds of crime is quite far-reaching already as they stand now, and that's without having introduced new rules on non-conviction-based confiscation, it's still pretty astonishing that the amounts, the confiscated amounts, are still relatively low. However, it should be pointed out that the statistics are very bad. There's not much statistics available. The ones that are published are really so vague that they don't really say anything. There's not a proper distinction between forfeitures and confiscation and the different and the value of the different confiscation measures. However, if you look at the published data for last year, it says that let's see now, 17 million euros approximately worth was confiscated and forfeited last year. Now, considering that the Norwegian black economy is estimated at 11 billion euros, this is obviously a very small amount. So that work needs to be done in order to increase the effectivity of confiscation in Norway. It's quite clear, and it's also something that's been discussed during the past few years now, and I think that the authorities are acutely aware that something has to be done in order to drive up the amounts of confiscation. Next slide, please. And with this, I just wish to thank you for your attention. Thank you.
Thank you so much for this so interesting presentation about the different model in your country. I have some question, also if it is late. In your presentation, you speak about the standard with the proof. That is for the direct confiscation. Is a criminal standard with the proof, but about the amount is a lower standard with the proof. About the illegal origin is a criminal standard, but if about the amount is a lower standard, how is it possible this difference? Because if I have to prove that the proceeds of the crime are $1 million, euro, and so on. If I say, okay, you have an amount or a sum, but I am not sure how much, and the standard is lower, but this means that I am not able to give a criminal standard to demonstrate beyond any reasonable doubt that the other amount is of illegal origin. I am only able to demonstrate that there is proceeds of crime, but I don't know what is the amount. So I don't understand this difference of a standard with the proof. I am the doubt that say that the standard with the proof, in order to demonstrate the amount, is a way to a kind of a trigger, no? Another question, there aren't debate about the admissibility of a reversal of the burden of the proof for extent confiscation. Because, for example, in Germany, it is clear that extended confiscation doesn't admit reversal of the burden of the proof. In Italy, there is a big debate, and the Supreme Court has affirmed and carry on affirming that is not a reversal of the burden of the proof, but is only a burden of allegation. Okay, it is not so clear, but is a burden of allegation. Is a debate, is some constitutional issue in your country about this aspect. And sorry, but it's so interesting. Where the perpetrator is unknown, is in the end a non-conviction based confiscation? Because the perpetrator is unknown, is a kind of action in rem. Is no? And preventive confiscation on the basis of Article 70 of the Criminal Code is when there is a serious risk of illegal use. Is a model of criminal confiscation is not too discretional. What kind? Also in Italy, we have a preventive confiscation, but the preventive confiscation for us is based on the circumstantial evidence of the legal origin, of the legal activities, and so on. This preventive confiscation on the a serious risk of a legal origin can justify everything, no? Because also about a sum of money, about cash. So it is a very, no, it's a very tough regime. It's a very, in my opinion, it's also a bit dangerous instrument. Sorry for so many questions. I don't know if other would like to ask something. No,
Perhaps I can respond to your
Yes.
questions now first. Yeah, so thank you. So the first question concerning the two different standards of proof. Now that's I think, a mechanism that's been accepted in Norway for the past 50 years or so. I think the idea here is that the prosecution has to prove up to the criminal standard that, for example, that there has been an offence, that offence has resulted or generated gain, that the whoever person then actually obtained the gain, who that is, if that's the offender, so that the causality is there. But when all of those aspects have been proved, it may in some instances be quite unclear what the amount of value actually has been generated. So there's been, for example, a number of cases where then there's been discussion about the going rate of cocaine on the market, for example. We don't know what the going rate of the cocaine is. So someone says, one amount, and another one says a second amount, and someone else says a third amount. Now, how can we prove? We need to be able to use some amount in order to calculate the benefit. Now, in this case, there's a particular provision, and this kind of provision you find in all of the Nordic countries, that where this is unclear, the court can, assess the amount that is to be confiscated. And when the court assesses the amount, then the standard of proof will just be a simple balance of probabilities. So I see a point that at some point it's kind of difficult to distinguish between the two, but I think the idea here would be, or what the kind of the ratio behind the rule is, that you need to separate between establishing the objective elements, that that there is a crime, there is profit, there is causality, and then after that, then it's a lower standard as regard the actual amount.
Yeah.
Did that make any sense?
Yes, in some countries there is a rule that the judge has the power to estimate the value of the process, but it is a bit. One thing is to estimate, no, but another thing is to say, okay, there are a criminal activity. This is true. There is a process, is sure, but I don't have to demonstrate the connection between a specific process. I have to evaluate. Is a bit an extended confiscation in some way? Please, Anna.
Hi, Johan. It's nice to
Hi
meet you
there.
again. Hi.
Hi there.
So I think that here it's maybe it's not that we are not that away from the thinking that if we have a court assessing the amount and we have this, how you call it, simple balance of probabilities. I think it's something like in Italy you are doing with the ISTAT criteria, so that the prosecutors are having this criteria to see like if a person is living in that region.
No, but it is not possible for direct confiscation.
But
this
exactly
is not possible for direct confiscation.
it's
Direct
exactly
confiscation means in Italy that you have to demonstrate that there is a crime, the process of a crime is 1 million, 2 million, or 100. It is not possible for the judge to estimate. If you are not able to demonstrate that that amount is the direct, you can estimate. You can in other models of confiscation in some way, the extent confiscation, the preventive confiscation. In that case, it is enough that there is this disproportionate value between your income or economic activity and your assets. It is extent confiscation, or also for preventive confiscation. The value is disproportionate, and or there are circumstantial evidence of the illegal origin. But this possibility is not. We have a rule, for example, for the crimes of corruption. When the judge is not able to establish which is the amount, the amount of the proceeds of a crime, the rule is that at least when it is sure that there is a proceeds of corruption, the rule is that at least the amount is equal to the bribery, to the what I have paid to corrupt. Bribery. Bribe. Yes, bribe is a crime. Bribe. This is a rule. But this is a rule to help the judge to evaluate this the bribe in the end. Not the bribe, to evaluate the process of the crime when it is not possible to find this. It is true that there is a process of crime, but I am not able to find. So there is this kind of presumption. But in other cases, we don't have this kind of rule. In some country, for example, in the Switzerland, there is this rule. Also before in Germany, no, that the judge can evaluate the amount of the process income.
When they want to set the income and the person doesn't say how much, the judge is able to estimate.
Yes, yes.
But I think in these cases and in the case you presented as well, I think it should be the judge should limit itself to say at least this is the amount that I presume he has, and basically to have like the lowest possible amount, you know,
Yes.
to choose the lowest possible amount, and then he can be beyond any reasonable doubt, be safe that this is this is at least what he has gained.
Okay. So okay, but I understand, but yeah, there are some doubt. Okay. The other for the other question.
Right. So the other question was the reversal of the burden of proof in extended criminal confiscation. There hasn't been much discussion. No, everyone seems to be.
Is applied in the practices?
Sorry.
Is applied in the practices?
Well, yes. I mean, it's required in law. So it's the extended criminal confiscation has been dealt with by the Supreme Court a number of times, and there hasn't really been any discussion about it. I think you may, you know, you may obviously question whether this is actually a reversal of burden of proof or whether it's rather a shared burden of proof. Before you know before the actual burden is there, obviously the prosecution needs to prove that first of all that the person holds these assets, and quite often there's the result of financial investigations into the finances of the person. They can see that there's a discrepancy there of 1 or 2 or 3 or several millions kroners. And obviously the person can't explain, how come the, what's the reason for the discrepancy between its actual assets and spending and legitimate income. So I think perhaps that it's reasonable to say that this is rather a shared burden of proof rather than at least a legal reversal of the burden of proof. Now, the third question relating to Section 74 of the Penal Code, I quite agree with you. It's that you don't really need any perpetrator in order to order confiscation. Pretty much amounts to a in specie confiscation proceedings. I mean, you don't need the offender. The thing is that you find the property in question. And provided that the conditions of the substantive confiscation rules are satisfied, for example, Section 667 or Section 69, then the asset can be confiscated. So, for example, if you find a unlawful fishing net, for example, which is a typical kind of thing in Norway, then you know that a crime has been committed, and then the asset can be, or the net can be confiscated, even though you have no idea who the owner is. Now, concerning the last question, preventive confiscation, again, I fully agree with you. I'm very skeptical about the use of preventive justifications for confiscation, because in this case, it's sort of brings you into, or it opens up the floodgates easily for very far-reaching confiscations. Because how do you limit confiscation where you base the measure on preventive considerations? Now, more also, even though the measure targets particular property, now in this case also it's the holder's person who becomes important, and in this case obviously it's also problematic that the person's kind of the person's living and the person's I don't know what word to use here. The person's lifestyle becomes an important factor in deciding confiscation. So, in my view, Section 70 ought to be used with care, and it must not be extensively interpreted. And it's also been my understanding that it's not used a great deal, and that traditionally it has actually been used mainly to confiscate pieces of property that can be potentially used for violent offences. So there are two aspects that need to be considered here. First, it's the nature of the property in question, and secondly, the nature of the person who holds that property. Now, in cases of where this is a sort of absolute illegality, where the actual property as such is illegal, well, then the nature of the individual obviously will be less important, because the property as such can be used to commit offences, and even though you do not have an offence, so that Section 69 can be used, well, in that case, Section 70 can be used. Now, it gets more problematic when the property is legitimate. Say, for example, a computer or a flat or a car or whatever, even money. And in this case, obviously, the context becomes more important. But that again is, as I earlier said, is problematic in its own right. So I fully agree with you. It's a provision that ought to be used with considerable care. But I do think that at least so far, it's not widely practiced by Norwegian courts.
Okay, thank you so much.
Thank you
for your so rich presentation. And now to conclude with Germany, with Anna. Researcher for the Humboldt University. Please, Anna. Yes.
Yeah, so we are kind of the last of Mohicans here. We have just Italy and Germany here in the room. So
No, we have many people.
We have online. Okay, so hi to everybody. I will keep it really short because the time is it's already gone. So we have nothing really new to declare. So it will be just a summary of our second report that Professor Heger presented in Catania. So we will just make clear which kind of confiscations are falling under this regulation. And in Germany, we may not have such a big problem. Like I think it could be a case in Bulgaria, like we heard today, or like in Lithuania. But in Germany, I think that it's pretty clear which kind of confiscation schemes fall under these regulations. So in Germany, we had a reform of 2017 on the criminal asset recovery, die strafrechtliche Vermögensabschöpfung, which basically transposed the directive of 2014 and in the national German law. So a first change was made on the terminology. And I heard already the report from Austria, so it would be interesting maybe for Austria to see if you also think about maybe connecting under the label Einziehung the whole situation, all these schemes, because in Germany this word Verfall it's not used anymore, so it's not anymore something up to dated. We have just the terminology Einziehung in order to conform with the confiscation as a wording in the EU level. So this was the first change. Second change, some of the most important maybe changes were in 3 confiscation forms. So now we have the extended confiscation, is the Article 73A StGB, the German criminal code, which is conforming with Article 5 of the Directive 2014 and the new Article 14 of the new proposal. The big question and big maybe peculiarity of the German system is that the extended confiscation is possible for all crimes. So we don't have any more, like in the past, a specific catalog of a list of crimes for which the extended confiscation would be possible. And this, from the reports that I heard, it's something that maybe Germany is going too far. We have to think maybe as a reform, what are we doing with the proportionality, what we are doing with the bagatelle delict, like some maybe not so important offenses. The prosecutor from Rome already mentioned that maybe Germany is sending too much requests. So it could be maybe also the problem that we have it for all crimes, that the extended confiscation is really permitted for all crimes. So just to say that it's going one step maybe beyond the directive. Second model, we have the independent confiscation, die selbstständige Einziehung. It's Article 76A, paragraph 1 till 3 StGB. This is exactly the Article 4.2 of the Directive 2014 and the new Article 17 of the new proposal, which was basically extended, covering now both factual and legal cases. So in Germany, it's possible in all these cases that we heard in some other reports, death, illness, absconding, statute bearing. So here we see that we are covering against all the cases with this article. And yeah, just to mention that this was also novelty because before it was not like that. So the third change, it was this new Article 76A4 StGB. This is really important because it's the so-called German non-conviction-based confiscation, the selbstständige erweiterte Einziehung. And this is the form that is not harmonized in the Directive 2014, but it could be harmonized now in the Article 16 of the new proposal. Although the last update that I had from the Council document, that it also closed, the whole discussions in the Council are over, there are a lot of changes in the Articles 16. So I don't know what will come with the new directive now, if this form will really pass or not. But in Germany, we have it. And as I said, it was a great novelty in the German legal order. And in the explanatory memorandum of the law 2017 was explicitly mentioned that this new confiscation form is comparable with the Anglo-American non-conviction-based forfeiture and the Italian misure di prevenzione. So we see how the German legislator from which jurisdiction was inspired. So just to remind, the confiscation in Germany is pretty much clear. It's in the criminal procedure and in the criminal code. In the criminal code, it's in the general part in the German Penal Code, Articles 73 to 76b of the StGB. And we have also several provisions for the confiscation procedural provisions in the StPO, so the German Code of Criminal Procedure. So here we have just to mention that near the criminal proceedings exist also independent confiscation proceedings. And these are the articles 421, 439 of the StPO. Here I make a pause in order to say that from the Lithuanian and maybe just for the protocol and the record for our project, here we see that for us it's pretty much clear that we have proceedings in criminal matters. But I think that in the Lithuanian and the Bulgarian system that they have this civil confiscation, we have to ask ourselves in these hybrid models if not maybe exactly the wording linked with the crime, but linked with criminal proceedings. So I think that there is a difference. In the Bulgarian model, there is not a link. They said that it's a totally separate proceeding. But in the Lithuanian model, they said that there is the evidence is used from the criminal proceedings in these confiscation proceedings. So maybe we should understand this link with the crime as linked with the criminal proceedings. And then we should really take these hybrid models and see and differentiate if we really see with the Bulgarian and Lithuanian models as really important for our project. Just to mention for the protocol, because in Germany we don't have such a problem. So we have a really important article, and this is the article 437 of the German Code of Criminal Procedure. And there is where the whole situation with the reversal of the burden of proof and the facilitation of proof is happening. So there the judge can find some indicators, some guidelines on the facilitation of the proof of the illegal origin of the assets. So we already know that the first one is the disproportion criterion that you all, a lot of you have, also Italy has it. It's the one mentioned in Article 5 of the Directive 2014 for the extended confiscation. And this is applied to both the German extended and the non-conviction based confiscations. So here we see that the court may base its conviction. So we have the standard of proof is the conviction, but the object of proof is the illegal origin of the asset. So there we have to be really to make the difference that the standard of proof is the conviction, is a criminal one, but the object of proof, we may not confuse ourselves, is a presumption of illegal origin of the assets based on indicators. And these indicators are first, this disproportion criterion, second, the result of investigation into the offense, so the criminal investigation. Third, the circumstances under which the object was found. So like if the prosecutors find suitcase with money in a house investigation. And fourth, other personal financial circumstances of the person concerned. So the criminal life of the person. So we see that these are the indicators that, as we said, there was a huge discussion in Germany if this is conform with some other principles, but after we, to me and to our eyes, also with Professor Hager that we discussed it really vivid, it's pretty much clear that we have the criminal standard of proof, the object of proof, as I mentioned, of the legal origin of the assets, and the burden of proof. There is no reversal in Germany. So in the criminal proceedings that is ruled, everything is not accepted, the reversal of the burden of proof. But I'm afraid that here, we are basically speaking for the same constellation, but we are just naming it. Some we are naming it Darlegungslast, like you have it also like these, how you call it in Italy, the that allegazione, exactly, and we have the same, we call it the same, but after all, I think also what Johan said now, we have the same, basically the same constellation, that the prosecutor should bring the first evidence, and after the person affected should just rebuttal this evidence. So I think that there, it's not something, it's maybe not the problem if how we will call it, but the problem would be with the right of the silence. So till which extent the affected person should give information, to which evidence. So we should really see on the concrete point, and maybe it's not the problem really the reversal of or Darlegungslast of the burden of proof. So this was the other point. And yeah, I will not go into detail to this debate, just mentioning that we have in Germany the direct confiscation, 73 StGB, the value-based confiscation, 73C StGB, the extended confiscation, 73A StGB, the independent confiscation, as I said, 76A 1 till 3 StGB, the new model that is applicable in the practice, and as I will tell you after some statistic, independent extended confiscation is the 76A paragraph 4 StGB, and the third-party confiscation 73B StGB. All these fall under the scope of the regulation of 2018, and we see that Germany was also like a blueprint for the new proposal of the directive. So really, it's easy to make the comparison with the articles of in the EU level that we have. So I will keep it like that. For the legal nature, we already said it. Professor Herger already mentioned it. We are more in the direction of the Netherlands. So there we don't have any penalty in the doctrine. It was highly debated if we have the net or the gross principle, but it's now the main opinion that we may have. Also, the German Constitutional Court said it several times. We don't have a penalty. We have a measure sui generis that it's similar to the civil unjust enrichment. So the idea behind this is that a person who knows that he has wrongfully obtained money cannot refuse to hand over the value if he has already spent it. So this was the main justification from the also the Constitutional Court in Germany, as a restoration of the status quo ante before the unlawful acts took place. They also mentioned, however, that could have also just the other justification purposes, such as the prevention or the reparation of the victim. And these are some additional justifications that also the German Constitutional Court accepted. But the main one is that we don't have a penalty, we have just this sui generis measure. So yeah, this is how it is. And just to remind that this new German non-conviction based confiscation is ruled because maybe some countries you don't have it anymore. So of course we would be happy if you are interested to take the example of Germany as a good provision. So we have here, we need an object to be seized on the suspicion that one of the offenses that I will say after, there is a list of offenses, not just the organized crime. So we have an object seized on the suspicion that one of the offenses has been committed. And as a rule, this could be separately confiscated, even in those cases in which the object derives from an unlawful act. So we don't need any guilt, of course, and it's impossible to prosecute or convict the person affected. So which are these offenses? And this is really interesting. We see that they are kind of the one that they were previously ruled in the extended confiscation, that after they were deleted. So the fear is here, now we have a list of offenses, but maybe with the years, we may delete also this and extend it to all the crimes. Or if we have just the money laundering, as it's saying here in the number F, there are in the academia a lot of people that they are saying here we have a door opener to all crimes. Because if we have the money laundering, it goes with the money laundering all the predicate offense also. So we have financing terrorism, forming criminal organization, child pornography, human trafficking, forced prostitution, forced labor, money laundering, tax evasion. We have also some other rulings on the Asylum Act, smuggling of foreigners, narcotics, also drug trafficking, and some other like with war weapons.
Always 76 paragraph 4.
76A, paragraph 4 StGB, exactly, is this new form. And yeah, this was the main situation in Germany. And just to remind that the German legislator why wanted to pass this new form, it was basically before the whole discussion in the EU level or while it was going on. The explanatory memorandum is saying that the situation was like that they were finding a sum of money in traffic and airport controls, and they had to leave the persons go with the money. So there they couldn't, and they couldn't have the direct proof of the commission of these offenses. So we needed this kind of facilitations of the proof. And this was why also the practitioners, maybe in this room, would be more familiar than me. So this was the situation. And just to say for the statistics that these new confiscation forms are working really in the practice, we saw that we don't have statistics for the implementation of the regulation, but we have statistics for how the situation is happening inside Germany. And there we see from this statistic, the Staatsanwaltschaften that I mentioned yesterday, the statistic of the prosecutors, that it was published this August 2023, that these autonomous proceedings, autonomous confiscation proceedings, these are also the one applied for the new confiscation form, the German non-conviction-based confiscation. They were, let's say in 2022, 292, or like they started recording from 2020 till 2022. These are the things that we have. And there is a gradual increase we see in the total number of these confiscation cases. And exactly, just to mention that, as you mentioned in the morning, we have this data from the Commission, but it's really the executed freezing orders in the same years that you mentioned, that you have the data from the Commission, 2021. The freezing orders executed in Germany, they are 50,009.9, and the executed confiscation cases, they are 63.5 to 1. for the same year. So Matteo, you mentioned that we had just 19 confiscation and 89 freezing orders. So we see that there is no comparison with the numbers that we have in Germany inside, I mean, the country, and not because of the execution of the regulation. Estimated total value, and I'm finishing with this because somebody, I don't remember which country showed us that it was this extreme amount of money, but in Germany from 2017 till 2022, the estimated total value of confiscated assets, I just took all the years and did the addition, it's around 5.5 million euros. So it's not that much, I would say. Thank you. Thank you for the attention.
Okay, thank you so much, dear Hannah. And now it is real late. Thank you, everybody. And see you next time for the next conference, which will be in the end of November, but maybe we can also extend our invitation for the next workshop of our group, of our team for our project. You can find the materials, the outputs, the questionnaire, the reports of each partner in our websites, recover.unicit.it. Okay, thank you so much, and until see you next time.
Thank you. Bye bye.
Bye.